And one other point that you guys might want to comment on is it's very difficult to get the Supreme Court to rule on these sorts of programs because the Supreme Court often finds that the program's secret and the party that's asserting that they are harmed has no evidence actually to show that surveillance was conducted on them. However, the ACLU just sued over the PRISM program once they got details of this. And I'm curious what you guys think about that as a potential Supreme Court case that where a party could say, look, there's been so much information collection that we know that information was collected from us and we have a privacy interest. Do you think that this is the sort of vehicle that might make it to a Supreme Court ruling that would get into this metadata question in a way that would update the Smith decision from the 60s?
That's a great question. You're absolutely right that the Supreme Court in the Clapper decision just in February dismissed an earlier ACLU suit to a surveillance program in which a group of academics and journalists and so forth said because they were calling abroad and because they knew that the calls abroad were being monitored, they were chilled in their association with potential clients and journalistic subjects and so forth. And the Supreme Court said because no individual journalist could prove for sure that he or she had been surveilled because the program was secret, therefore they had no standing to bring the case. And you're now asking, is this new program in which case we know that domestic telephone conversations are certainly being surveilled, would that lead to a different standing result? I could well imagine at least some of the justices in the Clapper majority saying that because no particular individual knows that his or her metadata is actually being examined, because you need the certification by the intelligence agent before any human being could see it, that there's a similar standing problem here. I don't know whether the really fascinating standing debate, standing is a technical lawyer's term, and the words fascinating, standing, debate have been used about as frequently as Mike Kinsley used to say, worthwhile Canadian initiative. I hope I don't get into trouble for that equation. But
the thing with the Canadian thing, it's not that they're not worthwhile.
Sorry, you are Canadian. I'm so
it's not
sorry.
that not worthwhile.
See,
that was voted the most boring headline, actually, is what it was. It was voted the most boring headline.
Yes,
a worthy Canadian initiative.
That's right, yeah.
It doesn't matter that it wasn't worthy. It's not interesting.
It's the most boring. Yeah, that's right. So standing, Canada is not boring, but standing is usually boring, except this year when both the Proposition 8 marriage equality case and also the defensive marriage case turned in different ways on whether or not people had standing to sue. So I think the court, as we heard last night with Justice Kagan, is acutely aware of the significance of imposing these standing bars. And maybe the second time around, if Justice Kagan is right that the court's aware of what's going on in public debate, they'll be less likely to dismiss it.
But it does run into this issue because, again, it gets down to these laws about lines. And I've already talked about public and private and national and foreign. And the court, I think, is generally much less interested in getting involved in issues that have to do with basically with foreign policy. No Supreme Court wants to be in a position where they're saying, oh, we don't agree with your policy towards Iran and we're going to change it. And some of this stuff is foreign policy. Some of how the United States decides to survey enemies or terrorists is simply conduct of foreign policy. And the Supreme Court is on a tenuous ground when you have 9 justices trying to decide how we should conduct military or foreign policy.